to reassess or really evaluate any permit or license that it issued. Again, I go back to Mono Lake, for example. We did go back and recondition licenses that were issued in 1941. So that's always a possibility. Is the policy suggesting we do that? No. Is it likely we're going to do that? Only in the event that there is some reason for us to go back and maybe recondition or reevaluate or provide additional approvals, changes, modifications to these dams, would we intend to do that? But it's always a possibility. And then secondly, if someone files a complaint or that would require us to go back and reopen something along those lines, we could do that. And the board does retain jurisdiction to be able to do that. Would they require bypass requirements to pit ponds or minimum in-stream flow requirements? That's always a possibility. As the example I gave you, that was a pretty major requirement that went all the way to the Supreme Court. But are we required to do that? No, but the state board is required to provide protection of the public trust where reasonable or feasible, depending on how you remember the statute. And I've cited it a few times, but it does allow the board and require the board to go back and evaluate that in some cases, but there's no intention to do that at this time. And with that, if you guys
well, and that's also independent of the policy. That would happen with or without the policy. So the policy would only apply to a licensed right if somebody had a license and they were filing a petition on it. Then they would, if the petition resulted in a change in in-stream flows, aspects of the policy could or would apply. But if you had a license right and you weren't planning on changing it or doing anything with it, the policy wouldn't apply. As Steve said, things can change. We have continuing authority, but that's kind of regardless of the policy.
And this is Aaron Miller is one of our engineering staff that's had a chance to look at this, I guess.
Having just looked at this really quickly, the equations that he's using, or his example here, I would say it's fairly accurate. It's I'd say it's a decent representation of what the policy is setting out to do as far as setting a minimum bypass rate and days you might actually be able to divert. Kind of anticipating this, I wrote some stuff down to bring with us. Some of the projects I've modeled in the office, we've looked at the actual total number of days it would be available to divert water, and I have it based on watershed size. One project had a 0.8 square mile watershed under the policy, and the average for a 56-year period of record was 6 days. The high, in a really wet year when there's raging floods, like he's suggesting, there were 22 days. For a 3.3 square mile watershed, the average over a 20-year period of record was 17 days. Again, for a 1.3 square mile watershed, the average number of days over a 15-year period of record was 14. The project in the 0.8 square mile watershed did not fully receive all the water they're requesting under their water right. It didn't reach the full amount that they've asked for. The project in the 1.3 square mile watershed did receive all of its water in almost every year. And the project in the 3 square mile watershed, I did it for reference quickly. There's no actual project at that point, but it was to have an example of number of days you would see under the policy.
Thank you. Supervisor Pinchot, you had a comment?
Thank you, Mr. Chairman. I'm disappointed to see that our state representatives left about a half an hour ago, because this is really important. I mean, and this that Mr. Light brings out is basically if you own 160 acres or less, you're not going to have the ability to develop yourself a water supply. I mean, and I have no reason, and I'm sure Mr. Light is right on his calculations, and that's the real emphasis of this meeting here today, I believe. Let's cut to the chase here. These guidelines, this proposed guidelines, are just not acceptable for we're not about growth and development in Mendocino County. We're sustainability. We've had a 2.7 growth in the last 6 years in this county. But I believe that everybody out there, whether they own 40 acres or 160, has the ability to develop a water supply, because frankly, the state ain't going to do it. And to put this sort of impediment on people is just, you know, I would call it the taking of private property rights, really. I think it extends that far, because I think everybody has the ability to own a piece of property and develop it for their own use, and that's what it's really about. This is not about really vineyard expansion or taking the water from the fish. I mean, look at the size of this county. If you own 160 acres or 40, don't you think that you should have a right, especially when we get huge amounts of rainfall in most winters, to impound some of that water to save enough to get you through the summer months? You know, but under these guidelines, as Rudy points out, you can't do it. Even if you hire a biologist and hire an attorney, under the guidelines, you can't do it. That's kind of what this is all about. And that's the message, I think, to you folks. I mean, it's getting late in the day. Everybody's getting a little bit tired, but I think that's, at this point I speak for myself, but I think that's the message that we want to get across. This is not acceptable under any standard.
Thank you, Supervisor, for your comments. We do have just a couple more people that would like to speak. So, Janet Pauley, followed by Rick Piffero, and the last speaker, you did not submit your name. So, okay.
Thank you, Chair Wattenberger, and thank you, staff. Hi, Steve. Nice to see you again. I'm Janet Pauley. I have a couple of comments. I've read most of the policy. I have probably a really naive question to start with, and then a more basic question to end with. At what point, and I don't find it anywhere in the policy, is there a legal, is the state board legally required to look at the economic impact of this policy if it were to be implemented? In other words, is there somewhere legally that the state board has to balance the benefit to fish to the economic impact to people? And my second point is, and question, if you're recommending diversion from October 1st to March 31st, basically winter diversion, that will require off-stream storage, more off-stream storage than we could currently have by quite an extensive amount. Is staff going to recommend to the state board to encourage and help streamline the process for landowners to build more off-stream storage, if this is the case, if this is what we're faced with?
Couple of quick comments to that. One of which is we did an economic analysis as part of the policy development, and as we go on a case-by-case basis, we're going to expand that economic analysis. But we have done that, and the board does have the authority to balance fish and economics and public interest and public trust and all those sort of things. It is part of their consideration. There are some limitations because some of these fish and species are listed under the Endangered Species Act. I think their oversight and their balancing authority becomes even greater limitations. Secondly, she mentioned a question about will the board afford some opportunities to assist or streamline the process in developing off-stream storage facilities or facilities that would meet the policy, and the answer to that is yes. We have been working with the Regional Water Quality Control Board to develop essentially a streamlined waste discharge permit for these types of projects. We're in the early stages of that development. It's probably going to continue independent of the policy itself. But some of these projects we know have other problems, not necessarily with environmental issues, but with downstream water users.